This is a summary of Part 1 of the Anti-Corruption and Economic Crimes Act. The Anti-Corruption and Economic Crimes Act of Kenya, No. 3 of 2003, revised in 2016, outlines the legal framework for addressing corruption and economic crimes within the country. This is a summary of Part 1. Title and purpose. The Act is officially known as the Anti-Corruption and Economic Crimes Act. It aims to prevent, investigate, and punish acts of corruption, economic crimes, and related offences. Definitions. Part 1 provides definitions of crucial terms used throughout the Act. Some important definitions include: corruption encompasses a range of offences, such as bribery, fraud, embezzlement, abuse of office, and dishonesty related to taxes or elections. Economic crime refers to offences under Section 45, which deals with the protection of public property and revenue, and any offence involving dishonesty related to maintaining or protecting public revenue. Public body includes government entities, the National Assembly, local authorities, corporations with public ownership or control, and organizations administering public funds. Unexplained assets are assets acquired during or close to the time a person was suspected of corruption, with a value disproportionate to their known income sources and lacking a satisfactory explanation. Application of the Act. The Act applies to conduct both within and outside Kenya if the conduct involves a Kenyan citizen and would constitute an offence under the Act if it occurred within the country. Note: this summary covers Part 1 of the Act. Other parts detail specific offences, investigation procedures, penalties, and other relevant aspects of the legislation. This is a summary of Part 2 of the Anti-Corruption and Economic Crimes Act. Part 2 of the Anti-Corruption and Economic Crimes Act focuses on the appointment and role of special magistrates who are responsible for trying corruption, bribery, economic crimes, and related offences. Here are the key points of Part 2. Appointment. The Chief Justice has the power to appoint special magistrates as needed for specific areas or cases. These magistrates must have experience as a chief magistrate, principal magistrate, or an advocate of at least 10 years. Jurisdiction. Offences under the Anti-Corruption and Economic Crimes Act are exclusively triable by special magistrates. The location of the offence determines which special magistrate will handle the case. Procedure and powers. While the Criminal Procedure Code and Magistrates' Courts Act generally apply, special magistrates are granted specific powers under this Act, including daily trials. To ensure efficiency, trials should be held daily until concluded. Power to pardon. They can offer pardons to individuals involved in an offence in exchange for a full and truthful disclosure of the circumstances and involved parties. This pardon aligns with Section 77, Section 6 of the Constitution. Sentencing authority. Special magistrates can impose any sentence allowed by law for the offences tried. This is a summary of Part 3 of the Anti-Corruption and Economic Crimes Act. Part 3 of the Act focuses on the establishment and functions of the Kenya Anti-Corruption Commission and Advisory Board. However, it's important to note that Part 3 has undergone significant amendments. Original structure. Repealed. The Act initially established two entities. Kenya Anti-Corruption Commission. Section 6 to 15 detailed the structure and functions of this commission. However, these sections were repealed in 2011 by Act No. 22 of 2011, Section 37. Kenya Anti-Corruption Advisory Board. Section 16 to 22 outlined the establishment, functions, independence, and procedures of this board. Current Advisory Board. Despite the Kenya Anti-Corruption Commission being repealed, the Kenya Anti-Corruption Advisory Board still exists under the Act. Here are some key aspects of the board. Establishment and composition. The board comprises members nominated by various professional bodies, including legal, accounting, manufacturing, religious, and labor organizations. The director is also a member. Functions: the board's primary role is to advise the now repealed Commission on its powers and functions under the Act. It also has other functions assigned by the Act. Independence: the board operates independently, accountable only to Parliament. Leadership: the board nominates a chairman and vice-chairman from its nominated members. These nominations require appointment by the President. Secretary: the Secretary of the Commission, appointed under the Ethics and Anti-Corruption Act of 2011, also serves as the Secretary to the Advisory Board. Procedures: the board follows specific procedures outlined in the third schedule of the Act. Key changes and current status: the sources don't provide details about the reasons for repealing the Kenya Anti-Corruption Commission or what replaced it. To understand the current anti-corruption framework in Kenya, you would need to refer to Act No. 22 of 2011 and subsequent amendments. This is a summary of Part 4 of the Anti-Corruption and Economic Crimes Act. Part 4 of the Anti-Corruption and Economic Crimes Act outlines the investigative powers of the Kenya Anti-Corruption Commission, referred to as the Commission in the sources, even though the sources note that the Commission itself has been repealed. This part details who can conduct investigations, what powers they have, and the procedures they must follow. Here's a breakdown of the key provisions. Who investigates: the Secretary of the Commission, or individuals authorized by the Secretary, have the power to conduct investigations. These investigators are granted the same powers, privileges, and immunities as police officers in carrying out their duties. Investigative tools: Part 4 grants the Commission a broad range of powers to investigate suspected corruption or economic crimes, including demanding property statements. The Secretary can require individuals suspected of corruption to provide written statements detailing their assets and how they were acquired. Requiring information from associates: the Commission can apply for a court order to compel associates of a suspect to provide information about specific properties and their acquisition. They can also require any person to provide information or documents they possess related to the suspect. Production of records: the Commission can seek a court order to require individuals or entities to produce relevant records, even if they are not directly suspected of wrongdoing. This includes ongoing production over a set period. Search and seizure: with a warrant, the Commission can search premises for records, property, or other items suspected to be connected to the investigation and not previously produced. Surrendering travel documents: the Commission can apply for a court order requiring a suspect to surrender their travel documents to prevent them from fleeing the country during an investigation. Arrest and detention: the Secretary and investigators can arrest and detain individuals suspected of corruption or economic crimes, holding them for investigation similar to police powers. Safeguards and limitations: the Act includes some safeguards to protect the rights of individuals under investigation. Non-disclosure: except with authorization, details of an investigation, including the identity of those involved, cannot be disclosed. Protection against self-incrimination: information provided by a person under investigation in response to a notice cannot be used against them in criminal proceedings unless they are charged with providing false information. Legal privilege: the Act explicitly states that requirements to produce information or records do not override legal privilege protections for communications between lawyers and their clients. Reporting requirements. Investigation report: after completing an investigation, the Commission must report its findings to the Director of Public Prosecutions, including any recommendation for prosecution. Quarterly reports: the Commission must prepare quarterly reports summarizing the number and nature of reports made to the Director of Public Prosecutions. These reports are submitted to the Attorney General and tabled before the National Assembly. Changes related to Commission's repeal: while Part 4 lays out these investigative powers, it's crucial to remember that the Kenya Anti-Corruption Commission itself has been repealed. It would be necessary to consult Act No. 22 of 2011 and any subsequent amendments to understand which body currently holds these investigative powers and how the overall anti-corruption framework functions in Kenya today. This is a summary of Part 5 of the Anti-Corruption and Economic Crimes Act. Part 5 of the Act focuses on outlining specific offences related to corruption and economic crimes. It defines what actions constitute these offences, who can be held liable, and includes provisions to address conflicts of interest and protect public resources. Here's a breakdown of the key offences outlined in Part 5. General definitions, Section 38. Agent. This broadly covers anyone acting for or on behalf of another person or entity, regardless of whether they are in the public or private sector. This definition ensures the Act can address corruption in both government and business dealings. Principal. The person or entity for whom an agent acts. The Act clarifies that if it's unclear who the principal is for a specific power held by an individual, that person is considered an agent of the government. Specific offences. Part 5 details a range of activities that are criminalized if undertaken for corrupt purposes. Many of these offences revolve around the concept of a benefit, which the Act defines broadly as any gift, loan, reward, appointment, favour, promise, or advantage. Secret inducements for advice. Section 40. It is an offence to receive, solicit, give, or offer a benefit in exchange for advice if the intention is to keep the benefit secret from the person receiving the advice. This addresses situations where advice might be influenced by undisclosed benefits. Deceiving a principal. Section 41. Agents cannot make false or misleading statements to their principals, nor can they provide documents containing false information, if it harms the principal's interests. Conflicts of interest. Section 42. Agents must disclose any direct or indirect personal interest they have in decisions their principal is making. Failing to disclose such an interest and then participating in the decision-making process is an offense. This section includes provisions for private bodies to authorize agents to participate even with a disclosed interest, highlighting the difference in standards between public and private entities. Improper benefits for trustee appointments. Section 43. It is an offense to give or receive benefits to influence the appointment of trustees for property. However, actions taken with the informed consent of all beneficiaries or under a court order are exempt. Bid rigging. Section 44. This section tackles collusion in tendering processes. It is illegal to offer or receive benefits to influence someone to refrain from bidding, withdraw a bid, or submit a bid with a specific price or conditions. Misuse of public resources. Section 45. This section covers several offences related to the protection of public property and revenue. Fraudulent acquisition/use. It's an offence to fraudulently acquire public property, services, or benefits. Disposal of public property. Mortgaging, charging, or disposing of public property without authorization is prohibited. Damage to public property. Damaging public property, including through actions that cause financial loss or disrupt public services, is an offense. This includes cybercrime targeting government systems. Tax evasion, evading taxes or improperly obtaining tax exemptions or reductions is an offense. Financial impropriety by officials. Public officials responsible for public funds or property commit an offense if they make fraudulent or excessive payments, fail to follow procurement or financial management laws, engage in projects without proper planning. Abuse of office. Section 46. It is an offense for a person to use their position to improperly benefit themselves or others. Handling of suspect property. Section 47. This targets those who deal with property they know or suspect was obtained through corrupt means. Dealing includes holding, receiving, concealing, using, or transacting with the property. Attempts, conspiracies, incitement, Section 47A attempting to commit, conspiring to commit, or inciting another person to commit any of the offences in Part 5 is also an offence. This emphasizes that even unsuccessful attempts to engage in corruption are criminalized. Penalties, Section 48 conviction under Part 5 can lead to fines up to 1 million shillings and/or imprisonment up to 10 years. An additional mandatory fine equal to double the amount of the benefit received or loss caused by the offence. Defenses and exceptions. Custom not a defense, Section 49 claiming that giving or receiving a benefit is customary practice in a particular field is not a valid defense. Impossibility, lack of intention, Section 50 if a benefit is offered or given as an incentive for a specific action, it is not a defense to claim that the action was impossible, not intended, or did not occur. Part 5 is essential because it moves beyond general definitions of corruption and lays out specific actions that constitute criminal offences. This specificity is important for enforcement and for providing clarity about what behavior is unacceptable under Kenyan law. This is a summary of Part 6 of the Anti-Corruption and Economic Crimes Act. Part 6 of the Kenyan Anti-Corruption and Economic Crimes Act focuses on providing compensation to victims of corruption and enabling the recovery of illicitly obtained benefits. It establishes mechanisms for holding corrupt individuals accountable not only through criminal penalties, as described in Part 5, but also through financial restitution. Here's a breakdown of the key provisions in Part 6. Liability for compensation, Sections 51 to 53. Basic principle: anyone engaging in corruption or economic crimes is financially liable for losses suffered by others as a result of their actions. This liability aims to provide full compensation to the victims. Improper benefits: individuals receiving benefits that constitute offences under Sections 39, 40, or 43, e.g., secret inducements, deceiving a principal, improper benefits for trusteeship, are liable for the value of those benefits to the affected parties. Interest and additional liability: the liable person must also pay interest on the compensation amount. Importantly, this liability exists alongside any other penalties they may face. Recovery by public bodies and the Commission: if a public body suffers a loss due to corruption, it can recover the amount directly or through the Commission acting on its behalf. This provision empowers the Commission to initiate civil proceedings to recover stolen or misappropriated public funds. Exception for complicit parties: individuals who are complicit in the corrupt activity are not entitled to compensation for losses they incurred through their own involvement. Compensation orders upon conviction, Section 54. Court-ordered restitution: when a court convicts someone for corruption, it can issue an order requiring the offender to pay any amounts they owe as compensation under Sections 51 or 52. Return any property obtained through corruption to its rightful owner. If determining the rightful owner is impossible, the property is forfeited to the government. Quantification of loss: the court has the authority to determine the precise amount of compensation or to establish a process for calculating it. Enforcement: compensation orders issued by the court are enforceable, just like orders issued in civil cases. Forfeiture of unexplained assets, Section 55. Targeting illicit wealth: this section provides a powerful tool to address situations where an individual's assets significantly exceed their non-legitimate income sources, and where a credible explanation is lacking. Procedure: investigation and opportunity to explain: the Commission can initiate forfeiture proceedings if, after an investigation, they believe someone possesses unexplained assets. The individual is given a chance to explain the discrepancy between their wealth and income. High Court proceedings: if the Commission is not satisfied with the explanation, they can commence proceedings in the High Court. Burden of proof: the Commission must present evidence of the unexplained assets. However, once they've done so, the burden shifts to the individual to prove that their assets were not acquired through corrupt means. Order for payment: if the court is unconvinced by the individual's explanation, it can order them to pay the government an amount equal to the value of the unexplained assets. Scope of assets: forfeiture can target not only the individual's assets but also assets held by others on their behalf or assets transferred to others as gifts or loans without proper consideration. Retroactive application: this section applies retroactively, meaning it can target assets acquired through corrupt conduct before the Act came into effect. Preservation of suspect property, Section 56. Preventing asset dissipation: to prevent individuals from hiding or transferring assets suspected of being linked to corruption, the Commission can apply to the High Court for an order prohibiting any dealings with that property. Targets: these orders can be issued against those directly involved in the corruption and against those who acquired the property later. Duration and extension: orders last for 6 months and can be extended upon the Commission's application. Challenge mechanism: the affected person can apply to the court to have the order discharged or modified. The court will only do so if convinced that the property was not obtained corruptly. Penalties for non-compliance: contravening a preservation order is a criminal offence, punishable by a fine of up to 2 million shillings, imprisonment for up to 10 years, or both. Additional powers for asset recovery, Sections 56A, 56C. Appointment of a receiver, Section 56A. The Commission can obtain court permission to appoint a receiver to manage and control property suspected of being acquired through corrupt conduct. The receiver acts on behalf of the Commission to secure and preserve the assets. Out-of-court settlements, Section 56B. The Commission has the authority to negotiate out-of-court settlements in both existing and potential civil cases related to corruption. This allows for more efficient resolution of asset recovery efforts. Recovery of funds and assets, Section 56C. Funds recovered by the Commission are deposited into the Consolidated Fund. Any other assets, movable or removable, recovered through investigations, court proceedings, civil or criminal, or settlements are surrendered to the Permanent Secretary to the Treasury. This provision clarifies the chain of custody and final destination of recovered assets. Part 6 of the Kenyan Anti-Corruption and Economic Crimes Act is significant because it goes beyond traditional criminal punishment. It incorporates mechanisms for victim compensation, recognizing that corruption has real victims who suffer financial harm. The Act provides a legal basis for them to seek redress. Asset recovery, by empowering the Commission to pursue civil recovery of illicitly obtained assets, Part 6 aims to deter corruption by taking away the financial incentives and making it more difficult for offenders to enjoy the proceeds of their crimes. This is a summary of Part 7 of the Anti-Corruption and Economic Crimes Act. Part 7 of the Kenyan Anti-Corruption and Economic Crimes Act focuses on evidentiary rules that are specifically designed to aid in the prosecution of corruption and economic crimes. These rules aim to overcome some of the challenges inherent in proving these types of offences, where evidence can be difficult to obtain and where corrupt acts are often concealed. Here's a breakdown of the key provisions in Part 7. Unexplained assets as corroboration, Section 57. Challenge: proving that a bribe or illicit payment took place can be extremely difficult. Solution: Section 57 allows the court to consider a defendant's unexplained wealth as corroborating evidence that they received a benefit through corruption. In other words, if the prosecution can demonstrate that an accused person possesses assets that cannot be accounted for by their legitimate income, the court can view this as supporting other evidence of corruption. Broad definition of assets: this provision includes assets held in trust for the accused or assets transferred as gifts without proper payment, closing potential loopholes. Presumption of corruption, Section 58. Reversing the burden of proof. Typically, in criminal cases, the prosecution must prove every element of an offense. However, Section 58 creates a presumption of corruption in certain situations. How it works: if the prosecution can prove that the accused person committed a specific act that is part of a corruption offense, as defined in Part 5, then it is presumed that the act was done corruptly unless the accused can prove otherwise. This shifts the burden of proof to the defendant on this particular element. Example: if it's proven that an official awarded a contract to a company in exchange for a secret payment, it's presumed they did so corruptly, and it's up to the official to rebut that presumption. Certificates for valuation and official information, Sections 59 and 61. Streamlining proof. These sections simplify the process of proving the value of property or an individual's official position and compensation. Official certificates as evidence. The Act allows for the admissibility of certificates issued by valuation officers to establish the value of property or benefits involved in corruption cases. Officers of a body to confirm a person's position within an organization and their compensation. Efficiency. This removes the need to call these individuals as witnesses in every case, saving time and resources. Limited accomplice rule, Section 60. Encouraging cooperation. Prosecutors often rely on testimony from individuals involved in criminal activities. However, the traditional accomplice rule often requires such testimony to be corroborated by other evidence to ensure its reliability. Exception for corruption cases. Recognizing that corruption cases frequently involve individuals who paid or received bribes, Section 60 states that these individuals are not automatically considered accomplices simply because of those actions. This means their testimony may not be subject to the same strict corroboration requirements, making it easier for prosecutors to use their evidence. Protection of informers, Section 65. Encouraging whistleblowers. Corruption often thrives in secrecy. Whistleblowers and informers play a vital role in exposing it. Immunity from retaliation. Section 65 offers broad protection to those who assist the commission or investigators. No retaliatory actions, no legal action, including disciplinary proceedings, can be taken against someone for assisting with a corruption investigation or providing information. Exception for false statements. This protection doesn't cover individuals who knowingly provided false information. Witness anonymity. Witnesses in corruption cases have the right to have their identities protected, and courts must take steps to prevent the disclosure of information that could lead to their identification. Significance of Part 7. By creating these special rules of evidence, Part 7 of the Kenyan Anti-Corruption and Economic Crimes Act makes it easier for prosecutors to build stronger cases, overcoming the evidentiary hurdles that often hinder corruption prosecutions. Hold corrupt officials accountable by increasing the likelihood of successful convictions. Encourage reporting and cooperation. The protections for informers are crucial for encouraging individuals to come forward with information, as they can be assured that they will be shielded from retaliation. This is a summary of Part 8 of the Anti-Corruption and Economic Crimes Act. Part 8 of the Kenyan Anti-Corruption and Economic Crimes Act addresses a miscellaneous collection of provisions related to corruption and economic crimes, supplementing the Act's core components on offences, investigations, and asset recovery. It covers various aspects, including consequences for public officers charged or convicted of such crimes, protection of informers, obstruction of justice provisions, and the Act's application to conduct outside Kenya. Here's a breakdown of the key provisions. Consequences for public officers, Sections 62 to 64. Suspension upon being charged, Section 62. A public officer charged with corruption or an economic crime is automatically suspended from their position at half pay. This suspension remains in effect until the case's conclusion, which should ideally occur within 24 months. However, they are entitled to continue receiving full allowances during this period. If acquitted or the case is discontinued, the suspension is lifted. Importantly, this provision does not prevent dismissal or suspension without pay under other applicable laws. Suspension and dismissal upon conviction, Section 63. A public officer convicted of such offences faces suspension without pay while appeals are pending. If the conviction is overturned, suspension ends. However, if the conviction stands, dismissal from service is mandatory. Disqualification from public office, Section 64. A conviction for corruption or an economic crime also carries a 10-year disqualification from holding any public office, whether elected or appointed. The Act requires the Commission to publish a list of disqualified individuals in the Gazette at least annually. Protection of informers, Section 65. Immunity from liability. This section reinforces the protection offered to individuals who assist the Commission or investigators. It ensures that no action, including disciplinary measures, can be taken against them for providing information or assistance, even if the investigation doesn't result in charges. The only exception is if the person knowingly gave false information. Witness anonymity. Recognizing the risks faced by whistleblowers, the Act mandates witness protection in court proceedings. Witnesses cannot be compelled to reveal anything that could identify an informer, and courts must redact identifying information from documents. Obstruction of justice, Section 66. Criminalizing interference. This section criminalizes actions that obstruct or interfere with the Act's enforcement. It covers a broad range of offences, including obstructing or threatening anyone acting under the Act, deceiving or misleading the Commission or investigators, tampering with evidence, destroying, concealing, altering, making false accusations. Penalties. Those found guilty of obstruction can face significant penalties, fines of up to 500,000 shillings and/or imprisonment for up to 5 years. Extraterritorial application, Section 67. Conduct outside Kenya. This section asserts the Act's jurisdiction over acts of corruption or economic crimes committed by Kenyan citizens outside of Kenya, as long as the conduct would have constituted an offence if it occurred within the country. This provision closes a potential loophole for individuals seeking to evade justice by committing these crimes abroad. Regulations, Section 68. Ministerial power. The Act grants the relevant minister the authority to issue regulations to ensure the Act's effective implementation. This provision allows for adjustments and clarifications as needed to address practical challenges or evolving forms of corruption. Transitional provisions, Sections 69 to 73. Repeal of prior Act and handling of pending cases, Sections 69 to 71. These sections address the transition from the previous Prevention of Corruption Act, Cap 65, to this new Act. They ensure that pending cases under the old law can be continued and disposed of under the new provisions, with necessary modifications. Establishment of the Commission and transfer of responsibilities, Sections 72 to 73. These sections establish a temporary director and outline the transfer of functions, assets, and ongoing investigations from the former Anti-Corruption Unit of the Kenya Police Force to the newly established Commission. This transfer seeks to centralize and strengthen anti-corruption efforts under a dedicated body. This is a summary of Part 9 of the Anti-Corruption and Economic Crimes Act. Part 9 of the Kenyan Anti-Corruption and Economic Crimes Act deals primarily with transitional provisions, which are special rules for managing the shift from a previous law to the new Act. This part ensures a smooth handover of responsibilities and clarifies how to handle ongoing cases that began under the old law. Here's a breakdown of the key provisions in Part 9. Definitions, Section 69. This section defines terms specific to Part 9 to avoid confusion. It clarifies that Repealed Act refers to the old Prevention of Corruption Act, Cap 65. Former Advisory Board refers to the advisory body that existed under the repealed Act. Repeal of the old law, Section 70. This section officially repeals the Prevention of Corruption Act, Cap 65, signaling the transition to the new Anti-Corruption and Economic Crimes Act. Handling of offences under the repealed Act, Section 71. This section addresses how to handle offences committed before the new Act came into effect but which were covered by the old Prevention of Corruption Act. It states that the provisions of the new Act, except for the specific offences outlined in Part 5, will apply to these older offences. This means that the investigative powers, asset recovery mechanisms, and other tools in the new Act can be used to address past corruption, even if those actions occurred before the new law was enacted. The new Act doesn't apply to conduct that wasn't considered an offense at the time it happened. This ensures that individuals aren't retroactively punished for actions that weren't illegal when they occurred. The Act cannot impose punishments that would violate the Kenyan Constitution's protections against retroactive penalties. Temporary Director and Transfer of Responsibilities, Sections 72 to 73. These sections manage the transfer of power and ongoing work from the old Anti-Corruption Unit within the Kenya Police Force to the new, independent Kenya Anti-Corruption Commission. Temporary Director, Section 72. The head of the Police Anti-Corruption Unit automatically became the temporary director of the new commission until a permanent director was appointed. This ensured continuity and prevented a leadership vacuum during the transition. Transfer of Operations, Section 73. All ongoing investigations, operations, and assets of the Police Anti-Corruption Unit were transferred to the new commission. This included physical and electronic files, evidence, and any other resources related to their work. The police were obligated to cooperate with the commission to facilitate a smooth handover. It's worth noting that this transfer of responsibilities didn't automatically mean that all staff from the police unit were transferred to the commission. The commission had the discretion to hire staff it deemed suitable, including through secondment from the police force. Amendment to the Limitations of Actions Act, Section 74. This section amends the Limitations of Actions Act by adding a new category of proceedings to which time limitations apply. The amendment clarifies that the time limit for taking legal action to recover assets or obtain compensation in corruption cases, as outlined in Sections 51, 52, 55, and 56 of the Anti-Corruption and Economic Crimes Act, is subject to the relevant limitation periods prescribed by law. This ensures that claims are brought within a reasonable timeframe. Overall purpose of Part 9. The provisions in Part 9 aim to prevent gaps or legal challenges during the shift to the new Anti-Corruption and Economic Crimes Act. They ensure that past corruption can be addressed using the new law's stronger tools, while also respecting legal principles and safeguarding individual rights.